point, she raised her objection again and was denied, even though the hospital could have switched out with another nurse. This was no emergency circumstance. This was pre-planned. She could have been accommodated even at that late moment. Her job was on the line, and potentially her license to practice medicine at all. She relented and suffered a severe traumatic moral injury. This is the moral injury that people suffer when you have that crisis of conscience, which we should be free to answer these fundamental questions of life. But not only that, it violated the law. So we investigated the case and issued a notice of violation to the University of Vermont. They've given us some encouraging signs as to their willingness to reconsider their policies, but we stand ready for any eventuality because we're here to enforce the law, as we did with the state of California. There, they passed a law called the FACT Act that was targeted against pregnancy resource centers. Again, these organizations, many of which are faith-based, that exist to provide women's options other than abortion. The state of California went after them, required them to effectively refer to free or low-cost abortion services in the state of California, and to otherwise post disclaimers in all of their advertisements. Meanwhile, exempting, as the Supreme Court said curiously, all sorts of other organizations that are in the same field that do not engage in abortion. The Supreme Court said it likely violated the First Amendment rights of these organizations, and we said that it absolutely did violate the Weldon Amendment, which prohibits HHS funds from going to a state that discriminates against entities that refuse to refer for abortions. Hawaii did the same thing. We reached an accord with Hawaii where their Attorney General's office issued an opinion binding on a state where they would not enforce their law, similar to California's, against any pro-life pregnancy resource center. So these are the wins that we're putting on the board because we're finally enforcing these laws. And it's not just a matter of enforcement, it's a matter of institutionalizing these protections. We started a conscience and religious freedom division within the Office for Civil Rights to make sure that these rights are treated at least as well as every other civil right. And we want to see this expand to the rest of the federal agencies to make sure we're changing the culture of government so that not only the Little Sisters of the Poor will never face a similar situation that they face, but that it will become unthinkable for the federal government to do so. To make sure that there's space for everybody of all religious convictions or no religious faith to partner with the federal government. So we're institutionalizing it by having a full division that will enforce these laws. And there are 25 different provisions, 25 that we discovered. And we issued a notice of proposed rulemaking, identified these 25 conscience protection statutes affecting healthcare that Congress passed, and are finally giving them life and force. The effective date is pushed to November 22nd. There have been lawsuits around it, which, to my mind, are baffling. Right? These are laws that Congress passed, and these are laws that should be enforced. This should not be controversial. Whether or not religious liberty and the enforcement of our laws rises and falls should not depend on who happens to sit in my office. It should not have to depend on having President Trump who's very forceful and fearless in defending conscience and religious liberty. It shouldn't depend on that. Just like civil rights, we've gone to a point in our country, thank God, where it's really the national consensus, regardless of the changes in the administration. That's where we want to be. And we're setting the stage now. And as we bring these cases forward, and of course, and I say this is every civil right, we also enforce HIPAA, if you believe there's a violation, bring them to OCR, and we'll figure out if it's